Morning.
SJC-13150, Commonwealth v. Marc C. Gibson.
Okay. Attorney Cornblow.
Good morning, Your Honors. Deborah Cornblow for Mr. Gibson. I'd like to begin with the issue regarding juror number 9. What happened here showed that juror number 9 was coerced into rendering a decision with which she did not agree, and here's why. The timing between the start of the deliberations and the time that the juror gave the note to the trial judge was 3 days. The timing between the judge's discussion, lone discussion with juror number 9, and the verdict was 1 hour.
Ms. Clover, I'm a little confused. I thought we've had cases that say basically when a juror says, I don't know if I can do this, we tell the judge, give him a little pep talk and send him back into the room. Don't we say that?
I haven't seen the word pep talk.
I guess that's my colloquial sense, but you're gonna have to interpret that.
But what happened here, the case law does say that it is okay for the trial judge to speak with the individual juror. And I'm sure your honors have seen the note. She said she felt intimidated into making a decision with which she didn't agree. So it was okay that he brought her in and spoke with her. However, he did not give any cautionary language to the juror, as the Commonwealth versus Chalou case that this court decided earlier this year prescribed. He should have initially told her that he could not discharge her unless she had a personal problem unrelated to her relationship with the other jurors. That language was never provided. And then after she persisted in saying that, this was difficult and it was very hard and she felt intimidated, the trial judge did not inquire of her before he sent her back after the pep talk, whether she could follow the oath that she originally took. He did not inquire about whether she would be able to decide the case only on the evidence. And very importantly, he put the entire responsibility on her as the minority to ensure that the other 11 jurors listened to her. But he never called the other jurors in as the majority to say, you also have to keep an open mind and everybody has to be respectful. He asked her to let them know, the person that already felt intimidated.
Counsel, I'm confused about that. Wasn't there something in the record that when the jury came back in that the judge did just that and said to everyone that you all need to listen to one another before sending them back out to deliberate?
No, what the judge said after the jury came back was an inquiry about just his general instructions, whether you've, the context was whether you have, I know that you haven't, received outside information, that kind of thing, but he never addressed the jury about specifically the need to keep an open mind and listen to even the minority. And it's telling that within 1 hour after he had this discussion with juror number 9, they came back with a verdict. And that was
well, let me read to you what I gleaned from the record, that the judge called the entire jury back in and said, get back to work and continue your respectful and collaborative work to reach a verdict.
Right, but that's not the type of cautionary language that either the Rodriguez case prescribed back in 1973 or that Justice Lowy's opinion in Chalou prescribed earlier this year.
Okay, but at least with the first part that you're mentioning, Rodriguez, there was no indication that the jury was deadlocked.
That does not matter.
Well, it could be instructive as to whether or not there was error here. That if you're saying he should have given the Tui Rodriguez instruction, but yet there wasn't a deadlock, isn't that somehow part of our analysis as to whether or not it would have been warranted?
No, because the case law specifically, I'm referring to O'Brien, Furman, and Chalue, all say that an actual deadlock is not required. The language of Tui Rodriguez has to be given whenever the court realizes there's an impasse. Many times a foreman or a forelady is not going to know the word deadlock.
Sure.
And is not going to say we're deadlocked. But the trial judge here should have realized that there was some kind of a problem, because it was the 9th day of trial, it was the 3rd day of deliberations, and then this juror comes in and says, I feel intimidated. And so he should have realized that there was a problem here. And many of the cases that the court cited in Chalue, many of the federal cases, the thrust of those cases, Webb, Zabriskie, and Smalls are the ones that come to mind, all really are very clear about how dangerous it is when a trial judge speaks to a lone juror.
But I think the difference here, though, first of all, Judge Salinger didn't have the benefit of Chalue, but the issue with that case was that the functional equivalent of a Tui Rodriguez charge was given to one juror, as opposed to all of them. Here, it's a landmine. We've got a landmine when you've got a juror talking about what's going on in the jury deliberation. It's very complicated. It's a difficult situation. Judge Salinger immediately does what the first rule of the case law, which is making sure that he doesn't talk about the deliberations in any way, and make sure that the juror doesn't talk about the deliberations in any way. And then he does, as Justice Gaziano colloquially referred to it, make sure that she understands her responsibility and has her go back into the jury room. And, this is hard, and I'm not sure that this wasn't an above average job.
Agreed, it was difficult. But unlike Chalue, where the court was taken, the trial judge was taken by surprise, after they said they had a verdict and the first juror says, it's not, I don't agree with the verdict. This judge had the benefit of before having the verdict, had the benefit of knowing that there was a problem. And although he did say, I want you to follow your conscience. I'm not asking you to make a decision with which you don't agree. There was a lot of other language that was not given. And regarding your question, Judge Lowy, about this judge not having the benefit of Chalue, well, the appendix in Chalue really is a summary of all of the case law that prescribes what should be done in this situation.
Going back to Justice George's point, though, going back to his point, we don't have a situation where there's been any determination of a, due and thorough deliberations. Judge Salinger doesn't make that determination of due and thorough deliberations. And then the jury does come back into the room, and you heard Justice George mention what was said. Why isn't that pointing the jury out to their responsibility to now go back in and listen carefully and respectfully to each other.
When you look at the context of the language that the judge used to the whole jury, it was nothing different than he had been giving every time there was a break throughout the proceedings. I'm reminding you not to, receive any outside information. It was referring to the general instructions that he had been giving all along. It had nothing to do specifically with, I'm asking everybody to keep an open mind and listen to everybody else's view. He never discussed with them anything different than he had been doing for the rest of the, during the rest of the trial.
But there is some temporal proximity, though. There was a hearing with an individual juror that the rest of the jurors that were deliberating knew that person was not in the room. Ostensibly, they were part of the whatever it is that caused this particular juror concern. They were there for that. So there is an inference here, I think. Isn't it reasonable to say that what he was admonishing them to was directly related to what had just gone on, and reminding them that they had to all listen to one another respectfully and work collaboratively and hopefully get to a jury, to
No,
a verdict?
because I disagree with that, because the other type of language that the cases say are supposed to be provided in this type of a situation, when the judge knows that there's an impasse, is he's supposed to tell the other jurors, they know she's out. She knows that everybody else knows she's out. And then he's supposed to also tell them, I don't want you to speculate about any of the discussions that I've had with this juror. And that was not provided either.
I don't want you to run out of time before addressing the other issue, though, because I'm interested in this issue about the theory. And I know you're saying that there were general verdicts and you couldn't really parse out with some of the stuff that had happened before, but I'd like you, if you could, tell me why the Commonwealth, in the light most favorable to the Commonwealth, didn't prove that the force here didn't prove that there was actual force here.
Well, I will answer your question, but first by saying that the judge at two different places, after number one, hearing all of the evidence, and then after hearing just the Commonwealth's evidence, and then after hearing all of the evidence, the judge decided that there was not sufficient evidence of force. And the other evidence that went against that theory and why there was insufficient evidence of force was her own testimony, the complainant's testimony, the defendant's testimony, and then you have more objective evidence as well. You have the same nurse who testified that there were no injuries on the complainant. There was some redness inside of her legs. And then you also have the exhibit, which is the complainant's medical records, which talk about her psychological, everything was normal. And there was just no other evidence of force other than what she testified to a year later about how she felt during the encounter.
Okay, so let me just ask you this question. So assume for the sake of argument that someone is unresponsive, and in order to actually accomplish the penetration, someone has to physically move someone in order to be able to do that. Are you contending that that's not force?
Well, that is some force. But if the court is going to construe that type of force, which is essentially what you're saying, I think the only force necessary to conclude the encounter, then everything is force. I mean, force is part of the act, but that's not the kind of force that the case law envisions.
She testified she tried to move away. He inserts his fingers, he repositions her. He'd used her key to come back into the room. The pictures he took of her, he's manipulating her in a way that indicates that some force is needed to do that. Why isn't that, he lies about whether he's in the room or not when he calls his friend. Why isn't all that enough to, in the light most favorable of Commonwealth, say that it was by force against the victim's will? And I'll emphasize again, she testified, she tried to move away.
Yes, she did testify to that, but she also testified that there was no pushing. There were no words exchanged. She didn't say anything. She said that she was moving and that she was trying to get away. One of the elements that one of the elements in the capacity arena is that someone has to, the defendant has to either know or reasonably should know of her state of mind. Now, when
Counsel, I don't want to interrupt too much, but we're getting to the end, you're over time, and I just have I've been listening to your argument and to Justice George's questions and thinking about this, and it's making me think that we've got the law of this all wrong, and that we really need to move to an affirmative consent model in sexual relations rather than the way it's framed now. Because if this isn't force, I don't understand what is. If this can't be force.
well, our case law does not have an affirmative.
I know it doesn't.
And what I think the judge got wrong in this case was the application of Berry. That's the main legal error in this case. Nothing in Berry limits its application to murder cases, and nor should it. But
the defendant doesn't have a right to the wrong decision. So if there's enough evidence to survive a required finding, then the judge would have granted the required finding if he had made a decision based on misinterpreting the law. We don't find that there was insufficient evidence.
well, Your Honor, if you agree with me on the law and you believe that Judge Salinger was wrong, I would urge you to defer to the credibility issues that Judge Salinger made in coming to his decision at two separate points. He touches on it after the motion for required finding of November 22nd, and then reiterates it again on November 26th. But you then still also have the juror number 9 issue and the issue of coercion. There's no other questions. I would rest on my brief and thank you for your time.
Thank you. Okay, Attorney Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. Beginning where the court left off with the sufficiency of the evidence, the Commonwealth proved this case far beyond the sufficiency standard. As the court has already made note of, the force used in this rape was both actual and constructive. The defendant snuck into the victim's darkened hotel room where she lay asleep in her bed, asleep after vomiting multiple times, being visibly intoxicated as witnessed by the defendant. He stood over her bed, removed the sheets off of her bed, removed the clothing off of her body, digitally penetrated her, repositioned her body after she tried to move away, then raped her with his penis. In addition to forcing her body against the bed because of his size, he was moving her body throughout the encounter, as was evidenced by the victim's testimony and the obscene photographs that he took of her, showing her stupor, her lack of consciousness.
What is the evidence of constructive force that you're relying on?
The evidence of constructive force is both appears in many forms, but Importantly, on transcript, volume 2, page 62, the victim plainly testifies, "I was scared." The force, the constructive force that's used against her is the fright and intimidation caused by him entering her room unannounced, uninvited, and standing over her. The fear associated with that all proves constructive force because constructive force shows the effect on the mind of the victim. And her state of mind, as she describes it during her testimony, was incoherent, weak, dizzy, out of it, unable to physically resist or react. She described herself as sick and incoherent. And the defendant was aware of her physical and mental state because of his direct witnessing of her intoxication and her illness.
Do you think that the nature of the photographs and the defendant actually manipulating her physically, it can be used as probative of what happened moments before?
Yes, I think it's evidence of her physical and mental state at the times. It proves nearly by itself her lack of capacity to consent. The photographs, she's in various states of undress, various positions. His body is visible in those photos, moving her in different ways. And in all of the photographs, those where you can see her body or her face, she is either appears to be unconscious or possibly partially awake, but with her head lolling to the side, her mouth open. It is more than a fair inference that she is not an active participant in those photographs, and quite frankly, that she was unaware of what was happening to her body at the time and was unconscious throughout the encounter. If the court would like to move on to the juror issue, it was both, the judge in this case handled the situation with the juror note appropriately and necessarily. I'd like to bring to the court's attention that both parties agreed to the judge's course of conduct before he spoke to the juror individually, agreed upon what he should say to her, did not object after his interaction with her, and at no point was the jury asked to be polled after the verdict. The judge, when speaking to juror number 9 individually, acknowledged her message, acknowledged how hard it can be to reach a verdict, but began the conversation by saying, "You will not be excused." And as the court has noted, he did not have the benefit of Williams, he did not have the benefit of Chalou, but he essentially followed the guidance given in those cases decided earlier this year. He told her she cannot be dismissed, and he cut off all conversation about the content of deliberations. And he did that multiple times effectively.
Should we not read anything, if we zoom out a little bit into the full mathematics of this? That I don't remember if this was actually like on a Thursday, but that the judge said, "Hey, if you don't come back today, you're going to come back tomorrow, or you're going to come back the following Monday," and that could necessarily breed acquiescence. That now we're just going to continue to this kind of stare down between this one person and the other 11. This person's already indicating that they're not feeling comfortable, and they kind of feel as if they're going to be pushed toward a decision that they can't in good conscience. And then no sooner does this exchange with the trial judge happen that about an hour later, we have a unanimous verdict. Can't we glean something from that math that perhaps a will was overborne?
No, I think that would be an unfair leap of logic. The conversation or the instructions that the judge gave to the jury about scheduling, which was essentially what he was talking about in that context, was, I believe, at the end of day 8. And that was the jury's one and only full day of deliberations. So at the end of that day, around 4 o'clock, the jury comes back before the judge and he acknowledges, "This looks like it's been a tough day. You all look tired," and gives essentially a pep talk to say, this is hard work, but you're going to get there. Here's the schedule going forward. And that really is all that he was doing, was saying, I expect you all to reach a verdict. If you don't, here are the days that you will be in court and you won't be in court. And in many ways, I can't see what the judge could have done differently. Rather than surprising them at another time about the scheduling, he was just giving them foresight into what the schedule would be of the court. And it certainly was not coercive in any sort of way. It was just the plain nature of a jury being beholden to the court. And I would like to clarify that the jury deliberated for a half day on day 7, 1 full day on day 8, and it was on the morning of day 9 that they returned the verdict. So when juror number 9 was before the court, that was only after a day and a half of deliberating. And why I think that is relevant is that both juror number 9 and the jury as a full panel had received the full jury instructions only a day and a half before, saying you all must collaborate, respect one another, listen to one another's opinions, in addition to the re-acknowledgement of those instructions on the morning of day 9. In addition to the fact that he appropriately spoke to juror number 9 when they were with the parties at sidebar, I would just like to reiterate to the court that at this point, a Tui Rodriguez instruction to the full jury would have been premature and inappropriate. As the court has already noted, there was no finding of due and thorough deliberations, and the decision to give a Tui Rodriguez instruction is never mandatory. It's always in the judge's discretion. And here the judge clearly did not, or the record reflects no finding of due and thorough deliberations and no basis from which this judge to extrapolate that there was any sort of impasse or any sort of deadlock in the jury room. If there are no further questions.
Okay, thank you.